So, the talk now, this is now where the issue comes in, the issue of the disciplinary committee. That defunct General Court Martial cannot automatically morph into a different outfit, even if it is to operate as a disciplinary committee, because the provision that created it with Section 197 of the UPDF Act has since been nullified. Therefore, for it to morph or to transform into something else, from a General Court Martial with a wide mandate to a committee with a limited mandate of discipline within the force, it has now to be the Parliament. And the court guided that if Parliament is doing it, they should be, they shouldn't be oblivious of the limit under Article 210 of the Constitution. And Article 210, which gives Parliament the mandate to make a law regulating the functioning of UPDF, is very clear. It's about to discipline. That's what they said. It's about to discipline. And they should not in any way provide for sanctions, penal sanctions, that involve custodial sentence or any other penalty like execution, death, or whatever, and so on and so forth. That is a preserve for the conventional courts. The decision they took, and for the pleasant surprise they gave to the nation. I'm sure many Ugandans did not see this coming, including myself. We are very, very skeptical about it, but it's because of our continued and sustained struggle, resilience, and tenacity that we had to push this up to the point where we are today. A few things need to be clarified. Now, before I do that, allow me to restate this, re-echo this statement we made here, that we are determined at Katonga here to dismantle all the tools General Kaguta Museveni is using to entrench a personal rule, a family rule. And we are glad one of the tools now, one of the arms, one of the weapons he has been using has crumbled. Now, we are glad. And what makes it more exciting is that it has come ahead of time, because our expectation was that by end of the year, we'll have brought down this instrument. But just after 1 month, because we made the announcement in January, then 31st January, we are done with that. We have achieved that mileage. It's a huge, huge achievement. We must celebrate. A few clarifications before we give you the way forward. One, since the decision was made on Friday, there's been a lot of passionate discussion about this, animated discussion. There's been an animated discussion within the public domain on this very important matter. Unfortunately, there's been some misconstruction of the same, which we need to correct and put into proper context. Number one, General Kaguta Museveni issued a statement which was paradoxical. On the one hand, he was lambasting the justices of the Supreme Court for the decision they made. But again, in the same statement, is indicating that actually they are going to correct the wrong they made. So it's a paradoxical statement. But we take exception to the language he used in that statement. We do take strong exception to that the country is not governed by judges, that the country is governed by Museveni and the voters. We need to remind General Kaguta Museveni, we have a constitutional order in this country. The Constitution creates a conventional system of government whereby we have 3 organs. We have the executive, we have the legislature, and we have the judiciary. each of them operating independently. Now Mr. Museveni is saying, is sending signals that actually the only instrument, no, rather the only organ that has the mandate is the executive arm, where there are electoral processes. That because the judges are not elected, therefore they don't enjoy the mandate of the people. We want to remind him about the provisions of the Constitution, which clearly state that judicial power is derived from the people of Uganda. Let him read the Constitution. And that the judges are commanded to exercise that mandate for and on behalf of the people of Uganda. So the judiciary is as important as the executive and the legislature. We don't need to lecture Mr. Museveni so much about the structure of government in relation to the three organs of government. So that statement is very, very unfortunate, and we condemn it in the strongest terms possible. That is number one. Two, their commentators, I think it's their maiden voyage in legal interpretation, who are asserting that the General Court Martial, as we knew it before, still exists. If they are lawyers, they are novices. If they are politicians, they are disingenuous. The judgment was unequivocal, was very, very clear. The Constitution created a single-lane judicial system. No, never. Never did they suggest, the members of the Constituent Assembly, that Uganda shall have a dual criminal justice system. No. It's a single lane. Now we have been having a system whereby there are two sets of courts. You have the conventional courts, and you have those who sit at Machindi. And they pronounce themselves very clearly on this. That was never the intention of the framers or the progenitors of the Constitution. Inasmuch as they recognized the historical significance or importance of a general court martial in instilling discipline within the military force, when it came to dispensation of justice, the justices were very, very clear on this. So Parliament exceeded its mandate in enacting the UPDF Act in 2005 by creating two things. One, the provision, that is 117, which is now 119, that vested mandate in the General Court Martial to try civilians of two categories. Those who were said to have brought themselves within the purview of the General Court Martial by either abetting crimes committed by serving military officers, or those who wielded weapons which had been considered the monopoly of the UPDF. Now, that animal, we asked when we were in the General Court Martial, that animal, a weapon which is ordinarily the monopoly of the UPDF, which one is that? It was the same question before the Supreme Court. Which one? It has never been defined. So in other words, there is no weapon which is a monopoly of the UPDF. And that's where Parliament went wrong. They also went wrong in that suggestion that even soldiers who are charged with capital offenses that attract serious and grave penalties like a death sentence or life imprisonment, that they can be tried by a tribunal which was not competent, manned or presided over by people who did not have necessary qualifications. So that's why they had to nullify Section 197 of the UPDF Act, which created the General Court Martial and never defined the qualifications for the members of the General Court Martial, save for the chairman, whom they said shall be at the rank of Lieutenant Colonel. But Lieutenant Colonel of what qualifications? You can be a Lieutenant Colonel but not a lawyer. You can be a medical doctor, you can be anything. But as long as you are Lieutenant Colonel, that you could qualify to be the chairman of the court. And also, so in other words, there are systemic problems or defects within the system which the justice has faulted. So in a nutshell, the point I am driving at is that the General Court Martial was disbanded because the provision that created it, Section 197 of the UPDF Act, was nullified. So, as we speak today, there is no General Court Martial. So if in your speak or in your talk, you refer to that outfit, the residue of it, as a General Court Martial, your statement would be unconstitutional. It would be actually, it would amount to contempt of court if you call this so. So from today onwards, please, nobody should be speaking about the General Court Martial. You can add adjectives as you want. The defunct General Court Martial, the former General Court Martial, the whatever, or whatever, the late. So there is no General Court Martial as of 31st January 2025. That is the new legal regime. That point I wanted also to emphasize it. Now the last one is the issue of amendment to the UPDF Act. In his statement, Mr. Museveni said they are going back to the drawing board. They are going back to Parliament to revisit the UPDF Act. Of course, there are a number of provisions, Section 2, Section 117, Section 100, that's a number of written of provisions that were nullified by the Supreme Court. So now he's saying they are working with the Attorney General and all those people in government to address those flaws in the Act and then come up with a new one. Take a note of the fact that there is a bill already pending before Parliament for the amendment of that same Act. There is one already where I think they wanted to legalize SFC as a unit of UPDF and a couple of other things they wanted to fix. So you can see they have already been tinkering with the UPDF Act. Now he's saying probably that they are going to withdraw the bill. That's what I think. Implicitly, he's suggesting that they are going to withdraw that bill and panel beat it and resubmit it to Parliament. We need to caution them. In law, there is what we call structural interdicts. Structural interdicts, these are consequential directives given by court after analyzing flaws within a system, defects within a system, and say, please, we have diagnosed this problem within the system. Do a surgery to the system and correct them as follows. This is what court observed and said systematic, they are systemic problems, not systematic, systemic problems. They are those issues which needed to be addressed, and they guided properly on how they can be addressed. So, if Mr. Museveni is going back to amend the law, well and good, but it must pass the constitutional test. It must pass the constitutional test in 2 ways. Number one, he should not in any way attempt to overturn the decision of the Supreme Court. That is the command in Article 92 of the Constitution, which is very, very clear, that Parliament shall not enact any legislation that has an effect of altering or in any way affecting a decision of court. So once court has pronounced itself on a matter, Parliament can only reinforce the decision of Parliament but not to upset it. Or the decision of court, rather, not to upset it. So, the talk now, this is now where the issue comes in, the issue of the disciplinary committee. That defunct General Court Martial cannot automatically morph into a different outfit, even if it is to operate as a disciplinary committee, because the provision that created it, Section 197 of the UPDF Act, has since been nullified. Therefore, for it to morph or to transform into something else, from a General Court Martial with a wide mandate to a committee with a limited mandate of discipline within the force, it has now to be the Parliament. And the court guided that if Parliament is doing it, they should be, they shouldn't be oblivious of the limit under Article 210 of the Constitution. Under Article 210, which gives Parliament the mandate to make a law regulating the functioning of UPDF, is very clear. It's about to discipline. That's what they said. It's about to discipline. And they should not in any way provide for sanctions, penal sanctions, that involve custodial sentence or any other penalty like execution, death, or whatever, and so on and so forth. That is a preserve for the conventional courts. Theirs, under Article 210, if Parliament is to make a law that passes that test, theirs should be limited to disciplinary actions that would entail like caution or dismissal from the force. It can be with the disgrace. And it's obvious, it's just logic. Logic. Many of these entities have got disciplinary units, like the prisons authorities. Do they send people to the gallows? The prisons, the police, the police standard unit, the professional standards unit. Yes. Even Parliament, the Committee on Rules and Discipline. Can they remand you? Can the chairperson, Honorable Katuntu, remand an MP or convict an MP and send him to the gallows? It's only logic. So that's the way it should operate. That was the guidance. And they